We've all had that frustrating moment with a neighbor, right? But what happens when that little dispute is about something you truly love, and your neighbor is the one who holds all the cards? Well, we're going to dive into a story about exactly that. It's about one homeowner, a view he treasured, and a battle that teaches us a whole lot about rules, power, and what it actually takes to win. I mean, just think about that for a second. This is the exact nightmare scenario a guy named Gregory L. Smith found himself in. You're up against the very person who's supposed to be enforcing the rules for everyone. So where does a story like this even start? Well, it all begins with finding the perfect home, for one very specific reason. So for Gregory Smith and his wife, this house in Mesa, Arizona wasn't just 4 walls and a roof. It was the house, the one they picked specifically for that amazing view. And this quote, it's pulled right from the official court documents. It just shows you right from the get-go how personal this was. That view was a huge part of their dream, and that dream was about to get blocked. Okay, so picture this. You're in the Mountain Bridge community. Mr. Smith looks out his window one day, same as any other, except there's a brand new flagpole blocking that cherished view. And who put it there? Yep, his backyard neighbor, who just so happened to be the president of the entire homeowners association. All of a sudden, Mr. Smith's castle had a big, ugly wall right in front of it. Now, this timeline tells you a lot about Mr. Smith's patience. He didn't just run off and sue somebody. For 4 solid months, from May to September, he sent over 10, that's right, more than 10 requests to the HOA, just asking them to do their job and enforce the rules. Nothing happened. So he took the next step, the official step, and filed a formal claim. And the HOA's response? Well, let's just say speedy was not the word. So what did all those emails and calls get him? Well, according to the community manager's own testimony, the HOA's big, official action against its own president was a courtesy call. Seriously. Not a formal notice, no violation letter, just a little chat. I mean, that one detail says everything you need to know about the conflict of interest at play here. All right, so the polite requests and courtesy calls went absolutely nowhere. Mr. Smith realized pretty quickly that his only way forward was to use the HOA's own rulebook against them. This is where the fight stops being about the view and starts being about procedure, about whether the HOA was even following its own rules.
Now, for anybody who doesn't know, CC&Rs are basically the constitution for a homeowners association. It's a legally binding contract that lays out all the rules for the whole neighborhood. They're supposed to keep things fair and orderly. And for Mr. Smith, this document became his most important weapon. And this right here, this one rule, Article 11.32, is the heart of the whole case. It's actually super simple. It says when you file a formal claim, both sides must, and that's the key word, must, meet and try to work things out in good faith. It's designed to stop things from getting out of hand. Mr. Smith did step 1 perfectly. The big question was, would the HOA do step 2?
35. That's how many days it took the HOA's lawyers to even get back to Mr. Smith after he filed his formal request to negotiate. By then, the whole required negotiation period was already over. This massive delay? Yeah, that became a huge piece of his argument.
So after trying everything else, Mr. Smith had no choice left. He took the final step and filed a petition with the state. This wasn't a neighborhood squabble anymore. This was moving the fight to a formal hearing where a judge would look at all the evidence and make a final binding decision.
So when he got to court, his case really boiled down to 2 simple but powerful arguments. Number 1, the HOA president making a decision about his own flagpole, that's a textbook conflict of interest and violates state law. And number 2, by totally ignoring his request to meet, the HOA broke its own rules, plain and simple. So the judge heard from everybody, Mr. Smith, the community manager, all the key players. And after looking at all the evidence, the decision came down. And it wasn't a straightforward win or lose. It was a lot more complicated, and you can just imagine how tense that moment must have been for Mr. Smith.
And here it is, the big reveal. The conflict of interest claim? The judge said no, denied. But the claim that the HOA broke its own rules, granted. A total split decision. So you have to be wondering why. How did the judge come to that conclusion? Well, the reasoning is actually pretty fascinating. Okay, so on the conflict of interest thing, the judge basically said, look, I get it. It looks really bad. But the specific state law they were looking at was written to apply to situations where money is involved. Since the HOA president wasn't getting paid for the flagpole decision, the judge ruled that, technically, this specific law wasn't broken. It's a super fine legal point, but it was enough to sink that part of the argument.
But on that second point, oh, the judge did not mince words. He said there was no valid justification for the HOA to just blow off Mr. Smith. They had a rule, they had to follow it, and they didn't. The judge found they straight up failed to negotiate in good faith and violated their own rulebook. It was a total smackdown on the HOA's inaction.
So, the million-dollar question. Did the flagpole come down? No, it didn't. But Mr. Smith was officially named the winner, the prevailing party. He proved his HOA broke its own rules, and they were ordered to pay him back his $500 filing fee. It might not have been the original outcome he wanted, but it was a huge victory for holding them accountable.
So, why are we talking about this one case in Mesa, Arizona? Why should you care? Because this story is packed with really valuable lessons for anyone who lives in a neighborhood with an HOA.
Let's break this down. First, that rulebook, your CC&Rs, it's not just junk mail. It's a legal contract, and it can be your best friend in a dispute. Second, you have to follow the process, step by step, just like Mr. Smith did. Third, document everything. His whole case was built on that clear paper trail. And this is the big one. This case proves that winning on a technicality, a procedural violation, is still winning. He didn't win because the flagpole was wrong. He won because the process was wrong. And sometimes that's what it's all about, just making sure everyone plays by the same rules.
And really, that's the question this whole story leaves us with. In the world of HOAs, it seems like knowing and using the rules can be way more powerful than just being on the right side of an argument. It really makes you think. When you're going up against a big organization, is mastering the rulebook the real secret to getting justice?